All right, now that we're moving through the course, the next portion we're going to discuss is escrow. And the escrow section of our course is going to entail you first taking a quiz, and then I'll do a recap of that quiz after you've taken the quiz. And then we're going to have Lynn Madison go through some of the scenarios and situations that have come up recently with escrow issues. So with that, please go take your escrow quiz. Thank you.
Please pause the video, go to the Earnest Money and Escrow module in your coursework, take the Earnest Money and Escrow quiz, then return to the Earnest Money and Escrow video guide.
Okay, let's go over the Earnest Money and Escrow quiz. Question number 1. For a contract to be enforceable, there must be earnest money. And the correct answer is false. It's not a requirement by any contract law or anything else. Now, most contracts do have earnest money, and the purpose of earnest money is to demonstrate the buyer's earnestness in wanting to purchase the property. Number 2, if earnest money does not get submitted by the buyer per the terms of the contract is automatically null and void. And that is also false. It is voidable by the seller, because the buyer has breached, but it is not automatically null and void. It is just voidable. A backup contract on a property should not contain earnest money. A brokerage cannot have earnest money on 2 contracts on the same property at the same time. And once again, that is false. If it's a backup contract, there's a good possibility that you do want earnest money, or the seller does, and maybe the buyer, by and through their demonstration of a large or a substantial earnest money check, will demonstrate to the seller that they are really interested and earnest in wanting to purchase the property. Number 4, earnest money must be deposited the next business day following the acceptance of the contract, unless the contract specifies a different time for delivery of earnest money to the escrowee. And that is true. It's just basically the license law says that we must just deposit it no later than close of business the following business day following the signatures of and the acceptance of the parties, unless the contract specifies something different. On a terminated contract, earnest money money being held by a licensed brokerage company must be given to the party as directed on the release form, or in other words, that's the consent to release form, the next business day after receipt of the form signed by all the parties, provided the check is cleared. And that is true. Number 5, number 6, license law authorizes release of earnest money upon the direction of the party's attorneys. And that can be true. It should be true, as long as the broker is very aware and has been made aware by their buyer or seller that their attorney can and will represent them in the transaction. Number 7, the seller cannot accept a second contract and sell their home to another buyer if they are refusing to release earnest money to the first buyer. And that is false. You basically have a dead contract, and then there's still a dispute maybe over the disbursement of the earnest money, but it does not prohibit the seller from continuing to market and accept another contract on their property. And number 8, when attorneys and title companies are holding the earnest money, they are bound by the same rules as brokerage companies. And that is false. Now, what you have to understand, the laws dictating how earnest money is held by different licensed professionals is established by and through their licensing law. And title companies and or registration, as it is with attorneys, they have a law and rules on how they have to hold escrow and how they can determine it when it can be released and such. Now, obviously, if the terms of the contract dictate a certain way of how the money will be handled, then that would be what would take precedent over the law. But attorneys have their own law as it pertains to holding escrow monies or trust monies, and title companies do as well. So they may very well be very similar to our license law, but they are not exactly the same, and they're not bound by those same rules. They have their own rule. That's what I'm trying to say. Okay, thank you.
Okay, now that you've had an opportunity to do that escrow earnest money quiz, just to kind of get an idea for your own self of where you're at with understanding all of this, let me take just a couple of minutes to talk to you about this. This is not about accounting requirements. That's your managing broker's responsibility to make sure the earnest money is deposited correctly. We're not going there. This is about issues that affect our clients. This is about us making sure that we understand how the earnest money is handled to assist our clients in understanding it when it comes to the delivery, the deposit, and the refund of the earnest money. So let's start with the delivery first. I know we covered this earlier in one of the other case studies very briefly, but let me just remind you that we do not have to have earnest money to have a legal binding contract. That was one of your questions on the little quiz. If we have a buyer and a seller who agree to sell a house to that buyer, if the seller agrees to sell the house to the buyer with no earnest money, if they're foolish enough to do that, we can still have a legal binding contract. But when the contract calls for earnest money and the earnest money is not delivered on time, it then gives the seller the ability to kill the contract because the buyer is in default. So one of the first issues is to make sure that the earnest money is in fact delivered on time as the contract calls for. So now whether you are going to deliver it yourself as the buyer agent, you now have taken on that responsibility. But if you're going to have the buyer deliver it themselves to whoever the escrowee is, then you want to really reinforce to your buyer how important it is that earnest money gets delivered on time. Now, the deposit of the earnest money. The license law requires that we deposit the earnest money the next business day after the contract has been executed or signed, provided the contract does not call for a different date of delivery of earnest money. So, as convoluted as that may have sounded, if the contract says that the earnest money is going to be delivered on the third business day, then we have to deposit it on the fourth business day. That's the law. We've been having some problems all over the state with checks bouncing, and we think we might have hit on why. We keep saying who's going to hold the earnest money. Is the listing office going to hold it? Is the selling office going to hold it? Is a title company going to hold it? Well, when you say hold it to a consumer, they don't understand. They're thinking, hold means they're not going to deposit my check. Well, now you've got a buyer who gave a check to a real estate office who they think are holding it until we get to the closing, when in fact they're depositing it the next business day and the checks are bouncing. So it's up to us as a buyer agent then to say to our buyers that check will be deposited the next business day. Because if the check bounces, we're back to the earnest money is not where it's supposed to be. So it's important that we make sure that they understand that. The other issue that's coming up is who's going to hold this earnest money. You need to make sure that you know if your brokerage company holds it or not. And most of the MLSs require something in there that says listing office holds earnest money, yes or no. Now, for many parts of the state, the earnest money is not held by any of the brokerage companies. It is held by a title company. So understand that the rules that we're talking about here are only for real estate brokerage companies who hold earnest money. If an attorney is holding it, or if a title company is holding it, all of these rules about depositing the next business day, and I'm going to get into the return of earnest money on a defaulted contract or a a canceled contract in just a moment. All of that stuff is going to be different if a title company is holding it. For example, we had a transaction up here. I'm from the north part of the state, but we had a transaction up here not long ago that the transaction got canceled. Mutual agreement on the buyer and the seller. The buyer wanted their earnest money back. Everything was signed. That was all done. Took 2 weeks to get the buyer's earnest money back from the title company, because the title company's rules for returning earnest money are different than ours. But what are our rules for returning earnest money? When one of us, you the listing office or me the buyer's office, are holding the earnest money, we deposit it the next business day. We've already talked about that. But now the transaction falls apart. Let's say it falls apart in the first 4, 5, 6, 8 days because of home inspection issues. The buyer does not want to buy the house, seller won't make repairs, whatever the reason. So now the buyer then says, I would like my earnest money returned. The first issue is we have to have joint written direction of the parties to return the earnest money. So when the buyer says, I want my earnest money back, he signs a form that says, give me my money back. If the seller refuses to sign the form, we cannot return the earnest money because we can't do it without the joint written direction of the parties. I joke all the time about that money could sit in the escrow account of that brokerage firm until pigs are flying through a frozen hell, because I can't give it back if I don't have everyone's signatures. Now, the attorney can sign for their clients, if there is one, but if we can't get the signatures, we can't return it, okay? So the first issue is buyer wants his money, seller won't sign it, I can't give the money back to the buyer. But the second issue is, it says in the license law that we have to return the earnest money the next business day after the escrowee gets that joint written direction signed by all the parties. If this transaction, provided the check has cleared. So if this transaction fell apart in the first 5 days and the earnest money has only been deposited 2 days ago, buyer wants his earnest money back, seller signs off on it, we still are not going to be returning it to the buyer, probably for another, week to 10 days, because the check has not cleared. We have buyers all over the state screaming, I want my money back. He's entitled to get his money back, but we as agents need to understand the rules. I can't give money back if the check hasn't cleared, because what if it doesn't clear? Now the brokerage firm is out that extra, $3,000 that they gave back, and I can't give it back unless I have joint written direction of the parties. It's real important that we as agents understand how all of this works, and that we have conversations with our buyers and sellers so that they understand it, because the other problem we have is that sellers automatically think that they are entitled to keep the earnest money if the buyer changes their minds. And that is not the case either. Obviously, if the buyer does not show up at the closing and the seller's sitting there and everything's ready to close and the buyer doesn't show up, I would argue that once it goes through the court system, that seller is probably going to get that earnest money. By the way, big disclaimer, I'm not an attorney. That's my opinion. But I don't know that, and we can't give that money to the seller at the closing even if the buyer didn't show up. So we need to understand this. We need to make sure that our clients understand it, because it does make us better for them if we can make sure they understand how all of this works.
You can now close the Earnest Money and Escrow video guide, return to your coursework, to the Fair Housing module, read the 5 pages on fair housing. After you finish the reading, play the Fair Housing guide.